It's a very difficult situation, but I think the matter has been interpreted before, around 2008, in a matter involving the current president, Buhari, when he filed an action. The issue of whether that and in between, that is, must have 25% in two states and the Federal Capital Territory. I think the pronouncement then was that the and is conjunctively. That was the interpretation then. But you know, it's about 14 years ago. It's enough time, maybe. The Supreme Court may have another look on it. But as of now, that is the interpretation the Supreme Court gave in 2000.
Contentious issue now before the tribunal. But when you look at the law, the Supreme Court, in 2 or 3 other cases that I'm aware of, says, look, Abuja is not a state under the Constitution, but we, Supreme Court, we accord it that status of a state. But in according Abuja the status of a state, we are not going to give it any privileges. I think it's in the one of the Boris cases in the Supreme Court. So the Supreme Court says, look, Abuja is Abuja. We will not impose any privileges because it is not a state, but we regard it as a state. Now the question is, Turenchi, as the Hausas will say, the use of and. You are now saying, this says, look, you must have 2/3 in 36 states and the federal capital. So, depending on which divide you are, as I always say, if you are for the proponents, they will say yes. 25% must include and will include Abuja. But if you are a constructionist, you are following the mischief rule or whichever this thing, you will know. If a man has 25% in 36 states, but does not have in Abuja, you will now say you can't be president. Does that make sense? You know, many people will laugh at you. And this question of 2/3, we have to be careful. By dragging in Abuja now into 36 states, we now have 37 states. Can we ever have 2/3 of 37? So we have to be very careful. But my view is this. Reading of that section, looking at all circumstances in Nigeria, you must have 2/3, generally, of all the states plus Abuja. So the word and, whichever way the judges want to look at it, is, you know, their own heading.
Far more important is the provision of section 134, subsection 2B of the Constitution. It is to say, it is to the fact that no presidential candidate can be declared a winner in this election without having 25% in the Federal Capital Territory. That is very important for the whole world to know that tomorrow's election, whenever to be finally declared, apart from having 25% in 24 states of the Federal Republic of Nigeria, the Federal Capital Territory is like a compulsory question. You can answer all that question. The Federal Capital Territory, without having 25%, you go nowhere. This is important. And finally, the broad outline of the 21st century, Dr. Abati, is clear. It offers opportunity for people who can work together.
Welcome to my channel, where we discuss everything and all things politics, especially about the 2023 presidential election in Nigeria and its aftermath. The issue of the status of Abuja in terms of electoral process, presidential election electoral process of declaration of a candidate as the winner of the election has been ongoing. And why it is ongoing is because the person who was declared the winner of Nigeria's presidential election on March 1st, Aswad Bola Ahmed Tinubu of the All Progressive Congress, did not get 25% in the Federal Capital Territory, Abuja. That has been an ongoing issue. But there is something I have been looking for, the Supreme Court's interpretation of the word "and." I've been looking for it straight from the East verdict in 2008, and I have finally found it. That is what we're going to look at. I have found the verdict of the Supreme Court on the word "and," its interpretation of the word "and," in the respect to getting two-thirds of the states of the federation. Two-thirds of the states of the federation, because in section 134 subsection 2b, it talks about that for anybody to win the election, the person must have 25% in two-thirds of the states, two-thirds percent of all the states of the federation and the Federal Capital Territory, Abuja. So that is what we have to look at now. I have found the Supreme Court judgment where they talk about it, how the Supreme Court interpreted it at that time. But that will be at the later end of this video. But because I have to lay the background for those who are not conversant with this particular topic that have been raging in Nigeria since after the February 25, 2023 presidential election in Nigeria, especially after the declaration of Aswad Bola Ahmed Tinubu as the winner of the election, and Tinubu has already been sworn in since May 29 as the President and Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria. And when we look at this interpretation, we are going to see whether Tinubu and his team should be worried based on this interpretation. And one thing is clear, the Anduaka was right in his analysis of it, but maybe he had a mix-up of name, because you can see he thought a while before remembering. He said whether it was this present president, he was talking about Muhammadu Buhari versus Yaradua. But the interpretation I have seen is Atiku Abubakar versus Yaradua in 2008. Now, this interpretation will also, perhaps that's one of the things that is also giving confidence to the PDP presidential candidate, that there may be chance for him in the election, that Tinubu's election may be nullified, because he was a participant in that. He was the petitioner in that in this Supreme Court judgment that we're going to look at. And but let me lay the foundation for it, because there are many people who this may be their first time of hearing about this matter. Now, this issue is basically to look at how the Supreme Court in 2008 took a decision on the word "and," which may nullify Tinubu's election. If this present Supreme Court is to go ahead with interpretation of "and" in 2008 and sustain it in 2022. And I'll tell you the reason why I used to ask, like Anduaka said that they may change their mind, and I keep asking, why should they change their mind? Why should the meaning of "and" change in 2023 from what it was in 2028? Now, let us look at the background of what we're talking about. And of course, you have seen the videos that explain some of these things in parts. You know, ahead of the 2023 presidential election on February 24th, Mike Ngini, a lawyer and former resident electoral commissioner of Akwa Ibom State, warned, and you saw it in the third video, where he was warning Nigeria and the rest of the world that no one should be declared winner of the election of February 25, 2023 in Nigeria without the person having 25% of the votes in the Federal Capital Territory, Abuja. Okay, so he was emphatic. It was as if he knew that there were plans to violate this section of the Constitution. So at the end of the day, the Independent National Electoral Commission Chairman, Professor Mahmoud Yakubu, without taking cognizance of this particular section of the Constitution, went ahead and declared Aswad Bola Ahmed Tinubu the president of Nigeria without Tinubu getting this compulsory 25% in the Federal Capital Territory, Abuja, according to Mike Ngini, a former President Electoral Commissioner in INEC. He had worked with INEC for over 10 years or thereabout at a very high level. And he should know better. And he's also a lawyer. Okay? And that I keep saying it, that if Mike Ngini, a resident electoral commissioner, should know that nobody should be declared president without getting 25% in Abuja, it is a given that there is no way Professor Mahmoud Yakubu will be ignorant of this fact. Yet, he went ahead and declared Aswad Bola Ahmed Tinubu the winner of the election. Okay, you saw him in the third video where he was emphasizing, warning about that. So nobody can accuse him of anything or being biased, because he said this thing February 24th, a day before the presidential election. So that's it. Now, in the first video, you saw a former Attorney General of the Federation and Minister of Justice, Michael Anduaka. And you can see that he started his own interpretation of it, of that section 134, subsection 2b, which says that for anyone to be declared winner of a presidential election in Nigeria, where 2 or more presidential candidates are in contention, the person must have majority of the votes cast. The person must win 25% of the votes cast in 2/3 of the 36 states of the Federation and the Federal Capital Territory, Abuja. And he said that this matter has already been settled by the Supreme Court in 2008. And he mentioned that it will involve General Muhammad Buhari and late President Umar Musa Yar'Adua. But I think maybe, if you see his, when he was trying to remember the person involved, maybe he couldn't pin it very well, but this has to do with Atiku Abubakar. He was the one that that this interpretation, that led to this interpretation. And incidentally, Atiku Abubakar is in court today, also challenging the election of Tinubu, and he's also hinging the nullification of Tinubu's election on this section 134, subsection 2b. So it is given that Atiku Abubakar also may be aware that he has an edge, that this is enough, this should be enough to nullify Tinubu's election. But like Anduaka said, he said maybe the Supreme Court, it has been 14 years now, maybe the Supreme Court will change their mind. But we are going to look at that interpretation. Okay, but he said that it is a settled matter. As at now, that is the law of Nigeria. Because it's not only the National Assembly that makes law, the pronouncement of the Supreme Court becomes law. It becomes law. Because whatever the Supreme Court pronounces becomes law. That's how Supreme Court is like a lawmaking body too, by its own pronouncements. Now, another interpretation of it was the one you also saw, a senior advocate of Nigeria, Clark, who insisted, you saw him, the fake complexion man, like half caste, is a senior advocate of Nigeria. He's insisting that Abuja is just like the states. Its status is like the state. It should be treated like any of the states, and that getting 25% is not compulsory in Abuja. You don't need to get 25% in Abuja. Okay? However, what he's saying is his opinion, because the Supreme Court has already done something about it, said something about it in 2008. And he was also citing other instances where the court or the Supreme Court said that Abuja should be treated as if it is a state. But that one has nothing to do with election. These were other matters that has nothing to do with election. But we are talking about interpretation of that section 134, which has to do with the declaration of somebody as the winner of a presidential election. So it's different from what he's talking about, because there are other places they say Abuja should be treated as if it were a state in terms of administration, in terms of revenue allocation and all that. But we know that Abuja is not a state, because if Abuja is a state, it will have a governor, it will have a legislative body, it will have all the things that a state needs to have to be a part of the 36 states. And this constitution was clear about what are the states in Nigeria. The constitution listed it. The constitution even went ahead to list all the local governments. So anything outside these states and outside these local governments listed in the constitution, you are your own. Okay, you can go and create anything you like. Okay, local area council, I know something like development areas, which many states have created out of their local government, but that's not recognized by the constitution. Okay, so Abuja is not like the states, but the constitutions, but the Supreme Court has in some areas interpreted is that it should be treated as if it were one of the states. Okay, now let us move into the reason I am making this video is because I saw the interpretation of the Supreme Court in 2008 in the word "and." So the challenge right now is, what will this present Supreme Court interpret "and" to be? Will it be different from what they interpreted it to be in 2008? Now, this interpretation, as I said, this "and" is gotten from section 134, subsection 2B of the 1999 Constitution, which I have also read out to you, which I still told you that it is interpreted to mean that after getting 25% of the vote cast in 2/3 of the 36 states of the Federation, you also have to get 25% in the Federal Capital Territory, Abuja. Now let us look at how the Supreme Court interpreted the word "and" in the case of Abubakar versus Yaradua in 2008. Section 134 1B in 1999 Constitution of the Federal Republic of Nigeria provides that a person shall have at least 25% in 2/3 of all the 36 states and the FCT. That's section 134, subsection 2B. Now, the Supreme Court in 2008, in trying to differentiate the word "or" from "and," made the following pronouncements. Please listen carefully. The Supreme Court, in trying to differentiate the word "or" from "and," made the following pronouncement in Abubakar versus Yaradua, 2008, 19 WNWLRPT 1120 at 7. Now, this is the citation of the quote where it appeared. So you can go and check it out in law reports, this verdict of the Supreme Court. Okay? The word or, this is what the Supreme Court is saying now. The word, that's what the Supreme Court said in 2008. Said the word or is a disjunctive participle. It's a disjunctive participle used to express an alternative or to give a chance of one among two or more things. The word or is a disjunctive participle used to express an alternative or to give a choice of one among two or more things. The person or individual has the freedom of the A to choose either between two things or among more than two things. So when you come to this, because you say that or means that you have a choice. You would either take A or B, C or D. Okay? Now let us go on how the Supreme Court interpreted or before they entered and. It is according to the Supreme Court, it is a function. It is a functional word, and courts of law interpret it functionally. Once a person or an individual makes his choice, he is glued with it. So when you have a choice between A and B, if you take A, you can no longer take B. A or B. Once a person or an individual makes his choice, he is glued with it. The courts construe the word mainly as disjunctive and not conjunctive. The word now they are about to enter and. The word is different from the and, which wears a conjunctive appellation. Now, this is in line with what Anduaka, former Attorney General of the Federation, said in the video you watched, that the Supreme Court interpreted that and as conjunctive. That is what this report is showing. Now, he said, continuing, the Supreme Court said, needless to say that the word and connotes the absence of choice or alternative. It means that when they say and, there is no alternative. It is not a question of choice. It's not for you to choose A or B. It's not a question of you to choose A or B. So the Supreme Court is saying that, needless to say, that the word and connotes the absence of choice or alternative. Thus, it is not an option to make 25% in the Federal Capital Territory. Rather, it is mandatory. Now, this is the law of the land as of today. And based on this position of the law as at today, as at the time INEC declared Tinubu the winner of the election, based on this, legal minds who are citing this Supreme Court judgment are insisting that INEC erred in law in declaring Asiwaju Bola Ahmed Tinubu as the winner of the election without meeting these constitutional requirements. Okay, now let us wait and see whether the Supreme Court will depart from this previous decision it has taken in 2008. Of course, there are some people who were in the Supreme Court at that time who are still there now. But the truth of the matter remains that why should the Supreme Court change the meaning of and in 2023 from what it was, from their understanding of it in 2008? That is the million-dollar question. Why would the Supreme Court change their mind from the meaning of "and" that they have interpreted in 2008 from what it is in 2022? That is where the problem lies for Bola Ahmed Tinubu. Will the Supreme Court change its mind on "and"? And if the Supreme Court changes its mind on "and", perhaps Bola Ahmed Tinubu will survive in that particular this particular issue, which is one of the grounds that Peter Obi of the Labour Party and Atiku Abubakar of the People's Democratic Party want Aswad Bola Ahmed Tinubu's election to be nullified. Okay? If the Supreme Court change their mind, perhaps Tinubu will survive this particular demand that Obi and Atiku is making. But if the Supreme Court said no, there's no need to change their mind of what "and" mean. That "and" has not changed the meaning of what it was in 2008. It then means that Aswad Bola Ahmed Tinubu's election will be nullified. And then the court will determine the next thing to do going forward. Thank you for watching this video, and if you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel. Hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you will be among the first to know. God bless you. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. God bless you and yours.